So the Supreme Court has relisted the challenges to strike down assault weapon and magazine bans nationwide once again. So we need to talk about the very interesting territory that we are now entering because of these multiple relists. Now, really quick before we jump into this video, I want to ask you guys for a favor. Looking at analytics, about 58 to 60% of all viewers are actually not subscribed to the channel. So if you want to support the channel for free, please consider subscribing. By no means do you have to. And also, if you want, comment down below just something positive. The algorithm, takes that and it signals to the algorithm that you enjoy this type of 2A content, and it should share my video and other type of 2A content to more people. As I mentioned in the intro, in this video, we're going to be talking about some very important developments in a couple cases which are challenging various state bans on so-called assault weapons and then also magazine bans as well. The critical cases are Snope versus Brown and then also Ocean State Tactical. These two cases we've been keeping our eyes on because the Supreme Court has now relisted these cases 7 times for conference. The most recent relist was March 7th, which pushes the number of relists in these two cases to about 7 times. About 6 actually, because there was a reschedule before the first conference. And all of this indicates that something very important is now developing in these cases. So we need to talk about what that is and what the Supreme Court may be signaling with these multiple relists. Now, if you're not aware, the Snope case is kind of the biggest case out of the two because it deals with a state's ban on so-called assault weapons. And this case was prior GVR'd by the Supreme Court after Bruen. The case involves the state of Maryland defining certain firearms as so-called assault weapons and therefore banning them within the state. The Fourth Circuit en banc panel then ruled in this case, and ultimately they once again upheld the Maryland ban, and they didn't really align their analysis at all with Bruen. Instead, they used the military use test. Essentially, the Fourth Circuit believed that since AR-15s in their eyes are useful in military service, they could be outright banned by the state. As a result of that horrible decision, the Snope case is now once again back in front of the Supreme Court, seeking review and reversal of what the Fourth Circuit said. And since this case is a final merits challenge on the constitutionality of state rifle bans, it's one of the most important challenges we have because it could also strike down other state bans on rifles and potentially magazines. Now, the Snope case was originally set for Supreme Court conference back on December 13th, but then the court preemptively rescheduled the Snope case. And then after that, it was relisted for conference about 6 times, with the most recent relist being Friday, March 7th. Now, the other case is Ocean State Tactical, and it deals with the state of Rhode Island's ban on magazines that hold more than 10 rounds. In that case, specifically procedurally, deals with the lower court denying a preliminary injunction that would have blocked the state's magazine ban for a temporary basis. The Ocean State Tactical case has now been relisted every single time along with the Snope case, despite the fact that it's interlocutory and it's dealing with a preliminary injunction. Now, you may be asking yourself, what is going on with all of these relists? They've now been relisted about 7 times. And why is the Supreme Court relisting these so many times actually important and now signaling maybe a different outcome of this case? Well, that's because all the Supreme Court analytics on prior cases show that a case has a higher odds of being granted review if it's relisted only one time. The data also shows that multiple relists, like what is potentially happening in Snope and Ocean State Tactical, could typically be a bad sign. When there are multiple relists, like 3 or 4 times, that could mean that the case is actually going to be denied review, and it's being relisted because maybe there's a dissent being written by 1 or 2 justices. However, there is also a different kind of interesting breaking point where a higher number of relists no longer indicates that a denial will actually happen in the case and maybe a dissent is being written. Instead, there could be multiple relists, a high number of relists that actually shows a heightened interest in the case. A higher number of relists oftentimes occurs in very high profile and also controversial cases. And this case here, which would deal with striking down rifle bans and magazine bans, that also falls within the category of potentially controversial cases that there's a heightened interest in, but maybe the Supreme Court is wanting to push it out further. So where is this coming from? Well, for example, the Dobbs abortion case that the Supreme Court recently ruled on was relisted 12 times before we got the official notice on the docket that the Supreme Court actually granted review of that petition. Also, since the Dobbs case, we've had multiple kind of leaks and narratives that came out that told us that the Supreme Court had already actually granted review to the case before the 12 relists. Now, that might sound confusing, but essentially the Supreme Court had already agreed to grant review to the case, but the docket did not show it until after 12 relists. You also have the high-profile Masterpiece Cake Shop case that was relisted 14 times before we got the official grant of review on the docket, and that came at the end of the October 2016 term. A high number of relists can begin to indicate two things are actually happening beyond just a denial and a dissent. What this could mean is that one, the justices actually voted to grant the petition and resolve the case summarily, so the petition gets relisted until the unsigned majority opinion is ready to be filed by the court. The second thing that it could indicate is that the justices voted to grant the petition and are deliberately actually delaying when to make the decision public and when to put it on the docket, perhaps to put the case off until the next term. So that's also what we saw them do in the Dobbs case. They already had actually internally decided to grant review to the case, but then they just did multiple relists to push it out to the end of the term and essentially grant review so that they didn't actually have to review it to the next term. So where does this data and all the developments in this case actually leave us? Now, the first strange kind of signal that happened in this case was when the Supreme Court actually denied review to the Gray versus Jennings case, which also dealt with an interlocutory review and the denial of a preliminary injunction in a similar magazine ban case. That denial of review was in a very similar case to the Ocean State Tactical case, but they didn't deny review to the Snope case, and they also did not deny review to the Ocean State Tactical case. So that also could be a good indicator, because if they had no interest in these cases, they could have denied it along with Gray versus Jennings. Also, as these cases climb to 7+ relists, the odds become less that they're going to be simply denying cert and then issuing a dissent. Justices don't need 4+ months to write a simple dissent. Instead, the higher odds and the higher relists could actually indicate that maybe there are internal debates, or that the court has already agreed to review the case, but they're just timing it and pushing it out to the next term. Again, there's also that outside chance that maybe something like a per curiam opinion is coming, which is an opinion written by the court without a single justice indicated as the author. This is used to dispose of the case very quickly without oral arguments, and I think that's less likely in these high-profile cases. I think it's maybe more in line with the Dobbs and the Cake Shop case, because controversial cases, maybe there's already a high interest in these and they're just pushing it out to a later date. Also, keep in mind that the most recent landmark Second Amendment cases, Bruen, that case was relisted 4+ times before it was granted review by the Supreme Court. And then you also had the Cargill bump stock challenge that was relisted 4+ times and then eventually granted review. So if you look at some of these similar Second Amendment cases, they were relisted multiple times before they were granted review. And then also you have these other high-profile cases like Dobbs and others, which were relisted even more times, and then they were granted review, but there was more of a timing aspect to when the Supreme Court actually put that on the docket. So as these cases climb to more and more relists, I think it becomes more likely that there is something strange actually going on internally with the Supreme Court. I think there's a higher likelihood as these climb in relists that the Supreme Court has actually decided to review these cases, but they're pushing them off for an official grant on the docket and kind of playing the timing game as far as maybe pushing it out to a later term. The fact that the Supreme Court also kept the Ocean State Tactical case and are relisting it along with Snope when it deals with a preliminary injunction, and when they denied review to the Gray versus Jennings case, that's also something very strange that could signal that something different is happening in these challenges. So these cases are now entering a very critical stage. All eyes are going to be on the Supreme Court again for next week for the order list to see what happens. But as it keeps racking up, as there are more and more relists, as we start pushing towards a higher number without a denial, that could actually indicate that yes, the Supreme Court is interested in these challenges and maybe they're just playing the timing game. So that's what's currently happening in these critical assault weapon and magazine ban cases that have now been relisted 7+ times. I know a lot of people have questions. This all kind of deals with kind of the behind the scenes Supreme Court stuff that goes on. Again, they could already internally agreed to grant review to this case, but we just haven't seen it actually hit the docket yet, and they could just be playing kind of the timing game. So as we get more information, as things develop, I will let you guys know. If you like this video and you'd like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by Armed Scholars, and this nation will be maintained by Armed Scholars.